Hi, I'm Bill Walker. I'm a local attorney here in Nevada City, California. And good afternoon and welcome to the seminar. Does that give you a good sound check? All right, great. Just to give you a little bit of background on me, I was hatched as a baby lawyer in 1981 from McGeorge Law School down in Sacramento. I kind of played around doing a couple cases here and there and deciding what I wanted to do. At the time, I really wanted nothing else except to be in a courtroom practicing law for either the defense or the prosecution, but I wanted to deal with criminal law. My background was that I always had real good grades, but I also always tested the limits, and I was in trouble a lot as a younger person. My teenage years, I was on probation for about 4 years and ended up becoming incarcerated in the youth authority. So for me, the criminal law had a big role in my life early on. And I was a political science major, American history major, and so I felt that that was really the best kind of law to get into. So what I did was to apply to a lot of different public defenders' offices and district attorneys' offices, and I was offered jobs, I'm thankful, in a lot of different places, but I chose to come here, and I've been in Nevada County since early 1983. So I was in the public defender's office. I grew up, as I say, and finally left home in 2003, so I was there just under 21 years here in Nevada City and up in Truckee. So this has, what we're talking about today, has been a large part, really, of my practice. What you do once you get into trouble and you've gotten out of trouble, how do you pull the resources that the system offers one to yourself so that you can move on and kind of leave your past behind you, so to speak. And that includes several different things, okay? So what I've done, I've handed out 4 little throwaway packets, I call them the handouts. The first one I printed out on my letterhead, and so if you look at that on the second page, back of the first page, what we're going to do is kind of follow the presentation part. Will follow that list fairly closely, so that we're first going to talk about the several different kinds of criminal offenses in California and how they're classified. And then we're going to talk about the various kinds of convictions and what happens upon sentencing. And then once that part, the courtroom part, is over with, then the various ways that can be utilized by the person that has been the defendant or arrested to have people forget about the fact that that had ever occurred. So the first thing I want to do is to, and there's a lot of this in the written materials, the first thing I want to do is just indicate that we're dealing with 3 different kinds of crimes in this seminar. The first kind are straight felony offenses, and California groups crimes according to their punishment, the possible maximum punishment. So as you probably are all aware, the possible maximum punishment on a felony conviction is a state prison commitment. There's misdemeanors, and the possible maximum punishment for a misdemeanor is only, so to speak, a county jail commitment. Okay, so it's a local incarceration maximum, almost always 6 months, a few are 12 months, and some are 90 days. So, but basically, 6 months in the county jail or 12 months in the county jail, as distinguished from years in the state prison. And infractions, and an infraction offense is defined as an offense that's only punishable by a fine. That fine can be a maximum of $250 as the base fine. There's a hybrid of crimes which affect a lot of people in this particular area, and they're called wobblers and wobblettes. A wobbler and a wobblette are both defined as a kind of crime. Really, you could think of it as it sits on the fence, and it literally wobbles back and forth. Sometimes it can wobble over and become a higher crime. Sometimes it can wobble over and become a lower crime. A wobbler in this kind of language is an offense that is alternately a felony and could be punished by a state prison commitment, or a misdemeanor and could be punished by up to 1 year in jail maximum. A wobblet could be, obviously, kind of, if you're following, an infraction which is punishable by only a fine, or a misdemeanor. In that case, the maximum punishment, according to the statutes, is 6 months. So the way that a situation occurs is that the police or a regulatory body comes up to a situation in which people are involved and they think that there's been an infraction or a misdemeanor or a felony committed. And as a practical matter, law enforcement personnel, part of their job is to be rated on how good a crime fighter this person is. And so for that incentive, and there's some other incentives for the law enforcement person, in my experience, to always choose the higher level of an offense if he or she has a choice between or among several different crimes. A good example is if a person steals a car, drives to a bank, goes in the bank, pulls out a gun, takes some money, and runs. Okay, well, when the district attorney or the police officer in the first instance, just saying the police officer for now, when that person first looks at that situation, the car theft is what's called a wobbler. So the car theft could be a misdemeanor car theft or a felony car theft. Well, in my example, what the officer would do is to say, well, heck, there's all these other crimes that are felonies and pretty serious felonies. And so what person in their right mind would think that the car theft should start out as a misdemeanor? Therefore, the law enforcement officer, using common sense, would just say, let's start off as a felony. So that's just one example. So there are reasons inherent in this person's job for choosing the higher level. There's also common sense reasons for choosing the higher level. The way that prosecutions go is the law enforcement or regulatory officer commences the prosecution by filing a piece of paper either with the court, the local court, or the local prosecutor. In our case, in Nevada County, the prosecutor is the district attorney. In a large county such as Los Angeles, there are actually several prosecutors. The two biggest, well-knownest ones, if that's the term, is the district attorney of Los Angeles and the city attorney of Los Angeles. Our city attorneys don't directly prosecute anybody here in Nevada County, except maybe Truckee. Truckee does sometimes. So the police report, let's say, goes to the prosecutor. The prosecutor reads the police report over and makes a charging decision, and that becomes the actual charge that goes to court. Now, the prosecutor can also read the police report and determine that he or she doesn't believe a crime should be charged for a variety of reasons that you could ask me about later if you really care. If that happens, then they issue a little memo called a no complaint, and they literally put a paperclip on the police report and they send it back to the law enforcement agency, and they have nothing more to do with the case. Sometimes the law enforcement agency will create a record. There's mandatory reporting that the state requires in some cases. So even if the prosecutor sends the paperwork back to the law enforcement and says, nice try, but we're not going to file this, there may be a record that has gone over to Sacramento. Generally not, though, but I just want to point that out to raise it as an issue. The prosecutor, when he or she says no thanks, literally they don't maintain a record of that no thanks. This district attorney keeps a copy of those memos, a hard copy, in other words, a photocopy. But the court itself doesn't have any of those records. The district attorney doesn't maintain a copy of the records themselves. It's just simply sent back to the law enforcement agency. Now, each agency has different policies about what to do with those reports. Many of them reduce them down to, in Grass Valley now everything's computerized. Nevada City's a little more old-fashioned. They still use little index cards. And they keep little index cards called field identification cards. And one way that the little card gets generated, or a computer record gets generated is by no complaint. So there's a record of the incident and the people involved and the date and what officer was involved maintained in a computer database. So that's if no case gets filed in court. Now, when a case is filed in court, the district attorney or the other prosecutor makes a decision as to how to view the particular charge. And then it gets filed in the court. In California, they're all filed in the superior court, whether it's an infraction or misdemeanor or a felony. And then the procedure for how each case is handled is a little bit different, and that's not really part of our discussion today. But what I want to focus on is that once a case gets filed, that is the actual charge that we are most familiar with when we talk about my charge was car theft, for instance. And that charge is brought by the prosecutor, not by the law enforcement person. So now there's a case in court. You come into court as the defendant. They send you a letter, or the bail bondsman has told you what day to come to court. You come to court as you're told, and they arraign you. They read the charge to you. They often give you a copy of the charging document and maybe the police report itself, and then you go and handle your case. Now, obviously, the case could result in a conviction, or it could be dismissed. Now, what I want to make sure everybody's clear of is even if the case is dismissed, the fact that a case was filed in court means that there's now a record of that case in the court itself and also in the prosecuting attorney's office. If you get a lawyer, your lawyer will also have a copy of that police report and the charging document. That becomes important later on. If the case results in a conviction, convictions in California are either by way of a plea or by way of a verdict. A conviction by plea can be either a guilty plea or a no contest plea, which results in a conviction either way, or it can be following a court or jury trial, which results in a guilty verdict, okay? For our purposes, there's not a huge difference for most of us whether we entered a guilty or no contest plea or whether we had a trial and were convicted. We can lump pretty much for almost all of us all that stuff in the same pile and deal with that as a group. There are some differences, and if it comes up, I'm happy to discuss that. They're covered in the written materials. Okay. When we get dismissed, we think the case is over with. But what happens when a case gets filed, and even many times when there's an arrest but no case filed, is there's a criminal record generated. And that criminal record is kept not only in the local place, and that can be just one law enforcement agency. Again, Los Angeles maintains a central law enforcement, a central data bank for all of the various law enforcement agencies in the county. Oftentimes, though, each law enforcement or each jurisdiction is going to maintain separate records in their own little places, which can become a problem later on. But then the biggest problem that we run up against in our lives is that the record goes to Sacramento, where it becomes a part of the big computer in the sky, and it's sent on to the FBI, where it becomes part of the universe. Okay, and what I want to make sure everybody understands is that there is no regulation or law or rule that says these records ever have to be taken out of the system. However, each jurisdiction also maintains its own rules and policies because there's no big rule, no law. So they all get to do pretty much whatever the heck they want. In California, for instance, most misdemeanors are purged by the Department of Justice in either 3 years or after 5-year chunks. But see, I did not cover that in the written materials because in the 25 years that I've been a lawyer, the classes of crimes, whether they're 3 years or 5 years, have shifted. 3 years, 5 years, it used to be 5 years, 7 years, that's shifted. Everything always shifts. So you cannot depend on purging information. If somebody tries to tell you, don't worry about this, it'll be taken off the computer after 5 years, it might be sooner. It might be never. This is not good advice to rely on, in my experience at least. And so, for our purposes, again, I think the important part of this is that when you come back years later, or even a short time later, you need to really spend a little bit of time thinking about all the different people that might have a copy, so to speak, of your record. Because the law has provision in it for dealing with each and every one of them, but generally it's up to you, sometimes it's up to the court itself to notify all of the little minutiae, all the little places where this stuff might exist. It's really tough. And I just want to throw something else in, because I'm a lawyer and I always confuse things. These are all public records, once a case gets filed, at least. And so when something's a public record as opposed to a private record, now there are private companies that come in and they just do nothing but type stuff all day long. They type divorces, they type plaintiffs, they type defendants in civil suits, they type how much you're suing for, whether it went to a jury, how much the jury gave you. They type all this stuff. And it goes into data banks that then they sell access to, and they make huge amounts of money off these little dinky pieces of information. So all this is important only because insurance companies and credit bureaus and landlords often, rental agencies, subscribe to some or all of these databases. Now, this is great information for them, but from my perspective, it's an invasion of my privacy, because they're going to make decisions later on based on just the fact that I was a plaintiff, or I was or this or that, without even talking to me about it. And so this is an area which the law is changing. There are federal laws coming and going, and state laws also. So I just want to confuse things and raise that issue. Okay. So we've covered felonies, misdemeanors, and infractions. If a person gets convicted of a felony or a misdemeanor, or an infraction, the court has a choice. The court can either sentence the person, or they can do a thing called suspend the imposition of sentence and place them on probation. If a court sentences you, then it's over and done with. You do your punishment, you do your restitution, you do whatever it is the court makes you do, so to speak, and it's over and done with. If you do not get sentenced, but if instead you're placed on one of the various kinds of probation, then you serve all or part of that period of probation, and the probation ends. Once the probation ends, you can immediately go back and you can immediately begin the process of trying to expunge or seal your records. If you do not get probation, if you're just sentenced, an infraction is just a fine. Your Honor, I'll pay that, in $25 a month payments, and after 5 months you paid the whole thing. The judge does not generally put a person on probation in that kind of a situation. It's just over and done with, okay? You have to wait for a year after it's once over and done with before you can start the process of expunging or sealing your records. And again, all this stuff is in the handouts and there's no tests. So the process for a conviction is really what probably most of us are directly impacted by. And I want to come back to that because there are a couple situations that I ended up covering a lot more thoroughly in my printed material. And so just today what I'd like to do is just keep it short and simple. If you're arrested and the case is filed, but it gets dismissed, then there's a law in California called 851, which again is in the written materials, which allow you as the defendant to ask the court to declare you factually innocent, seal your record, and at the end of 3 years, the record is automatically destroyed in all the jurisdictions that maintain that record. That's a pretty cool thing. What I want to talk about today is for those of you who have a continuing relationship, let's say, with the criminal justice system, the thing to remember if a case gets dismissed is what you want to do is you want to start the 851 process right away, immediately, and I mean before you leave the courtroom, because it's much easier to do if the court still has some power over you, something pending. And so just giving notice to your public defender, your lawyer, the DA, if you're just there by yourself, or the court itself, that you want to do this 851 process stops that clock ticking. Now, I bring that issue up because the 851 process is extremely rare here in Nevada County. Each county has its own kind of traditions. Many counties, especially the bigger ones, if a person, generally you'd hire a lawyer in my experience to do this, or a paralegal that has some experience. If the prosecutor is presented with a situation in which at some past time a case was filed but then dismissed, and the defendant has been in no further trouble, you get a couple letters of recommendation, person's employed, there's been no other police contacts, they'll usually stipulate or agree that the defendant was factually innocent. Now that can be important if you want to be a teacher and you were a defendant once, or you want to be a lawyer, or you want to be bonded, or a private investigator, for instance. The stipulation is something that's an agreement. It's just it's a statement of agreement, and they don't have to give that to you. So in Nevada County, the policy is, and it has always been, I only have experience with 2 DAs, but even the DA before that had the same policy. We won't stipulate that you're factually innocent unless we really believe you're factually innocent. And that's really tough. I mean, generally, as a practical matter, you, the defendant, or you, the arrestee, you are participating in some way in an incident, and around you something comes to light which might be a crime. Well, that's really all it takes. If, on the other hand, somebody steals my car, goes and robs the bank, and they arrest Bill Walker, because the license plate returns back to Bill Walker, well, once I prove I was in Ohio at the time, and it wasn't me, it couldn't be me, it was a female, and she was thin, and, it's just not me, then they could say, oh yeah, well that Bill Walker didn't do it, so this Bill Walker must be factually innocent. So then I could go back to court and prove, so to speak, that I was factually innocent. Okay? If you're in court before, and the DA dismisses your case because they're either not interested or they don't think they can get a conviction, if you say, I want to do this 851 procedure, then you do not have to be factually innocent. And what the law says is that the court should grant that motion for you. It doesn't have to, but as a practical matter, it should. So once your body leaves the threshold of the courtroom, then the court has no more jurisdiction over you. You can still come back and file that 851 motion, but there's another number that comes after that 851.8E, and you have to follow a different procedure, which includes having a whole hearing. Now, as a practical matter, coming to court and doing a hearing usually means hiring a lawyer, spending a lot of money, delays, time delays. So again, I really caution those of you. I'm not looking to put lawyers out of business or paralegals out of business, but I am looking to say, look, you can, cut down on your expense, you can cut down on your time if you have a continuing relationship with the courts by advising people before you even get out the door, let's start this 851 process. Okay, so if that doesn't apply to you and you get convicted, then if you're placed on probation, again, don't forget that you can come back in the middle of probation, really at any time, and you can either ask your probation officer to take you off probation early, or you can petition the court yourself to modify probation. The law, and I did not include that here, I can give you the number if anybody cares, the law sets forth a procedure for a modification of probation and says the court can modify, change the terms and conditions at any time when it seems interesting, and it can even dismiss or terminate the probation early whenever the court feels like it. It's kind of like, I feel like it, so I think I'll do it. Of course, when that happens, you immediately file this other paperwork we're going to quickly be talking about, and then get it over and done with. Sometimes, then again, especially here in Nevada County, the judges will actually look at the case. Again, I mean no disrespect to judges in other counties, but there's so many cases and thousands a week that they often just sign this stuff and get it off their desk. In Nevada County and the surrounding counties around us, even in Placer, they actually, to my experience, look at stuff, have questions, often will have their secretary or their clerk call you up and say, the judge is wondering about community service, the judge is wondering about restitution, you didn't do this or you didn't do that. And that's a good thing because you at least have an interest. The court is showing some interest, and that, in my experience, is a good thing. Once you get the case, once you're over and done with your probation, then there's 3 different things that we're talking about today primarily. So all of this was really introductory. I'm sorry to be so long-winded. A conviction can be expunged or sealed in one of several different ways. I don't prefer the term expunged myself, and I have a real I say why in the printed materials. It's really misleading. The number that we're mostly familiar with here is 1203.4. And a 1203.4 motion, what it really does is it says to the court, look, I've fulfilled all my obligations to you. I've had no further crimes. I'm living a crime-free life. I'm a really good person. So therefore, allow me to withdraw my guilty no contest plea or take away my verdict, replace it with a not guilty plea, and then dismiss the case. Now that sounds pretty cool, like it might never have existed. However, there's nothing in that law that says that anybody has to destroy any records. And this is a big problem, because what does happen is that the Department of Justice in California, they have a date on which the case was commenced, the original charge, and then in the middle they have a column for the arresting agency and all that stuff, and then their little printout says the disposition over here. And the disposition would show dismissed per 1203.4. So what does that do for us? Well, what it does for us is, and oftentimes, we can truthfully say we've never been convicted of a crime. Okay, well, great, except that when the employer goes and finds out lawfully about felony convictions, if that was a felony crime, they're going to find out that we got a case, we got a disposition, and that disposition was dismissed per 1203.4. Now, if they care, they'll look up 1203.4 and they'll see the only way you can have a case dismissed pursuant to 1203.4 is to first get convicted. All right. So then the employer will come back to you and say, I'd love to hire you, except you lied on the application. You were too convicted of a crime. Okay, so in the 25 years of experience that I have, this is a huge thing. And so my belief as a practical matter as an attorney is that the attorney should advise anybody that's coming to him or her of that fact. Just tell them the story. Just tell them like it is. Because my experience is, especially with local employers, because I'm the kind of person that makes phone calls. So I'll call and talk to the employer. And I'll say, well, look, I understand why this person said they were never convicted because they had this thing. And this thing says, and again, it's on the printed materials, okay? So I'll talk really fast. But the thing says that all infirmities, all bad stuff floats away. Okay? So they think, therefore, they've never been convicted. So don't hold it against them. That doesn't make them a lion sack. That means they're just like normal people. And as a practical matter, the employer has almost always said, geez, Walker, if they had only said that from the get-go, That means they've already hired somebody else, in my experience. But anyway, or they'll say, oh yeah, I never really thought about that. Well, send them back over, and they'll continue the discussion. So, as a practical matter, what I advise people is the facts, and then I tell them, say, no, I've never been convicted of a crime. However, I have a case that was dismissed per 1203.4. Okay? Now, this is clever, and I'm not looking to split hairs here, but what you're doing is you're disclosing the fact that you've had a contact with law enforcement without directly confronting the issue that you were convicted, but then it was dismissed later on. And you are saying correctly that it was dismissed. So you are neither lying, nor are you really telling the whole complete and total truth. Okay? So to me, it's something to watch out for. Again, lawyers, teachers, who else? Private investigators. What's that? Nurses. Nurses, correct. Big thing, nurses. Thank you. They ask you other questions on employment forms. And they ask you, have you ever been arrested for any offense? Now, is that a legal question? The answer is yeah. You can always ask any question you want. Okay? Can I legally ask you to disclose misdemeanors and infractions or juvenile cases? The answer is I can legally ask you to do that if I tell you that you don't have the right to, that you don't have to tell me that, but that in order to complete this application, your choice is to disclose that stuff truthfully to me. I had to do that when I became a lawyer. And that was a big issue for me because I had gone back and had my juvenile case sealed, and that was, my God, that was a huge thing for me. I didn't know whether that would come up or not. So I sought a lot of advice on that one. Do I disclose, And this is the thing. These are the nuts and bolts issues that we deal with. Even when a 1203.4 is granted in Nevada County, for instance, they still have the record here in the court. And it's still a public record. If you have a 1203.4 granted, I can bop into this courtroom, pay a few bucks, and get a copy of the police report in some cases. Now, the court now is starting a program where they no longer maintain those records. And so if they haven't already expunged or gotten rid of those police reports, they will shortly do that. But I was just helping a client less than a month ago, and down in Madera, I was able to get copies of the police reports. This is somebody who's going for a license, and even though we had done a 1203.4 earlier and had the case reduced to a misdemeanor, they still demanded, so to speak, a copy of the police report, and I couldn't find it anywhere else. So I thought, well, maybe the court still has one, and because, again, it's a small county, they hear about things, they have more space to store stuff. They're really not supposed to maintain copies of police reports. They had it, so they made a copy and they sent it up. For me, it worked, okay, but for you, it might be terrible. It might be really bad. But it's just something to be aware of, again. The 1203.4 is a wonderful thing. You can get back almost all of your rights that you gave up when you got convicted. But it's not perfect. It's not perfect at all. And you guys probably have more to say about that than I do. And so the examples that are going to come up today are really going to inform this discussion more than I can. If you have a Wobbler conviction, a lot of times the thing that matters to us is that we got convicted of a felony. Now we're off probation, we haven't committed any more crimes, and we want to say we've never been convicted of a felony. A better route to go than a 1203.4 is another number called a 17B3 motion. Okay, so there's a penal code section called 17B3. This thing says that any time after the conviction, anybody can come before the court and ask the court to exercise its power to reduce a Wobbler felony down to a misdemeanor. Now, what I want to say about that is that almost always happens later, sometime after probation ends. And again, each court has its own policies. You're technically entitled to it whether or not you've been convicted of any more crimes. So if at the beginning of your criminal career, so to speak, you got a Wobbler felony, Then later on, you got 3 or 4 more felonies, one of which resulted in a prison commitment. You can still come back and ask to have that very first case 17B'd and reduced down to a misdemeanor. Of course, the court may or may not grant that. You don't have a right to that 17B motion. And I want also, because I didn't put it in the materials, to make sure that everybody is really clear. If you get sent to prison on a felony Wobbler, you cannot come back later and have it 17B. You just lose that possibility. And so you can come back. You cannot either do a 1203.4. So you lose those 2 possibilities if you're sent to prison. You can come back later and do another thing called a certificate of rehabilitation. And even if you complete probation, even if you only have 1 case, this is where this gets kind of eyes glazing over, but you can always ask for a certificate of rehabilitation. You can always ask for a pardon, except for a few little misdemeanors that are really little. And there's some exceptions I'll come back to. But the process is really cumbersome. And I looked around for some forms. I did not have forms to provide for a certificate of rehabilitation and a pardon. Although, just as we were waiting around here, I got copies of some old forms that I'm sure would still work. And if you want those, I'm happy to provide those for you next week. And the Law Center might have it. Great. The Attorney General right now is not maintaining a web page on certificates of rehabilitation and pardon because they're, again, as a practical matter, for the last few governors, it's been a really rare thing. Okay, so what I want to do basically is get into the forms, but to finish off with certificates of rehabilitation, that's something that is useful if you're bonded, or again, if you're in one of the professions or in some other occupation that requires licensing. It's more icing on the cake in my experience. The real important stuff is a 17B reduction to misdemeanor and the 1203.4. If you were unfortunate enough, as many of the people that I work with now, to have been sent to prison, cleaned up your life, and then had 15 years of good law-abiding citizenship when you get all kinds of degrees in school and now you want to go contribute to society, you got to go for a pardon. And this is a very depressing area of the law, in my experience. It is, you know, and I'll be as neutral as I can possibly be. There is no there are guidelines that are generated by the governor's office. Each governor has his or her own secretary that does nothing except deal with certificates of, pardon applications. They all have their own policies. Ultimately, it becomes, in my view, a political decision. It is not a criminal justice decision. You're asking a politician for relief. You're not asking a judge or a DA or even an officer for relief, or let alone your priest. And so the governor really doesn't have a good reason to say okie dokie unless you can come up with a good reason for him or her to grant you this kind of extraordinary relief. So just being a really good person after you really screwed up is not going to generally be enough. The only thing that I've found, and I cannot predict, by the way, who will get granted a pardon or who won't. I've tried probably fewer than 10 times I've been approached in my career to actually pursue a pardon. If you do a certificate of rehabilitation, which is more common, it automatically becomes an application for a pardon. However, then how is that pardon presented becomes an issue, because the court will just take the certificate of rehabilitation, send it on up to the governor's office, and it becomes a lump of paper, you know, on somebody's desk. And so what I've done in the past is I've actually supplemented the court record with additional materials, and they've always been quite polite and accepting and really kind of interested. I mean, it's all they do for their job. So anyway, but I've never had one of those people granted a pardon, and that's tough. You know, I've gotten a multiple murderer granted a certificate of rehabilitation by this court here in Nevada County, but that person is still pending a pardon. This is a guy who almost works miracles. I mean, he almost walks on water. He's a great guy. He should get a pardon, in my view. But that's not our decision to make. I mean, so it's a very difficult situation. I've handed out also juvenile cases. A really quick word about juvenile cases. Juvenile cases are private. They're not public records to begin with. They really are private. And in every jurisdiction, those records are really quite difficult to get access to. So again, as a practical matter, you have the law in California is that one is not convicted of a crime, no matter what it is, if one is in juvenile court. It's just simply not a conviction. And no one will be able to access those records absent a petition being granted by some judge in some county, which gives them specifically the permission to access those records. And judges are just really, again, in my experience, and I've probably 15 or so counties, they're just really not granting those petitions, although we got notice in the public defender's office. If I was somebody's lawyer, I got notice that somebody somewhere had filed a petition to find out what the client had done. My kid, I was going to say, what my client had done. So then I have to make a decision: do I go down and appear, or do I phone, or do I write a letter, or do I just yell? So juvenile cases are pretty cool. Juvenile cases are also cool in the sense that once you get to be 18 and are off probation, or 21 and are off probation, you can go back and actually have those dumb things sealed. So that's really the only other area of the law where you actually get things sealed, torn up, and everybody gets ordered to tear theirs up. Again, even the public defender did, or the lawyer. I get them now, and I have to destroy the records in my case. So juveniles are pretty cool. Let's see. Before I turn to the forms, do I need to start? Okay. So the process that you need to do is you need to gather information to start the 1203.4, the 17B motion, or the certificate of rehabilitation and pardon. The information you need is pretty standard. It's your name, birthday, social security number, the date of your arrest. It's all in the forms, and it's all in the written material, examples I've given you. The important thing is you need to know a case number. You need to know a county. Now, again, being a public defender, most of my clients have led broad lives. And so when they come back and they want to clean up their records, I'm usually asked to go hunt down various convictions in various different counties. And that's kind of a tough thing to do. It used to be, again, as a practical matter, just being a small county, I would say to the probation officer, or I'd say to the court, here's what I'm looking for, and they could run me a rap. And the rap sheet would, this little thing that all the cops get, why shouldn't I get it? I'm a lawyer. I'm not even, they're not even lawyers. So, but it's just what we talked about. It's a date, case number, charges, and a disposition. It's a really cool thing, a rap. I can't get them now. They've clamped down on the laws to the extent that really they're very, very difficult to get. The DA is not allowed to give them out. They're not even allowed to run them without making a record that they've requested it. So same thing is true with court personnel. Same thing is true, with the probation department. And so what has become more important was something that 25 years ago I used to actually cry over because it was so frustrating, and that's going to Sacramento and getting a copy of your rap directly. That used to be nearly impossible. Fortunately, these guys nowadays, and I've got some experience in this area, are pretty fast, very courteous, and very helpful down in Sacramento. So this is one area where get in now before everybody gets jaded, And that is, I've handed you a packet of forms. You start with the packet that says Office of Attorney General. And on the web, the Attorney General maintains a site where you can navigate down, and then the format of this handout is that if you look at the bottom of the page, that's the actual URL or web address where you can type in and just get there directly. Or you can just navigate the menus, which are sometimes a little not intuitive. But What it does is it, in a lot of words, explains the process of getting your rap sheet. And it starts with being fingerprinted. In your syllabus, I've attached several pages that tell you the current locations in El Dorado County and Placer and Nevada County and Sierra County, including Truckee and the Lake. I might have put in Sutter, I forget. But anyway, most of the local counties where you can go and get your fingerprints taken. The fingerprint process is no longer done with ink. It's done with a computer that looks like a Xerox machine. And you just kind of lean on it for a minute, and it flashes some lights at you. It takes away your soul, and it gives you a printout of your fingerprints. And then they actually print it out onto a form called a 10-print card, hand it to you. You leave, and you mail it along with an application to the Attorney General. So just what I've done in the written materials is to tell you how much money it costs. Generally is a fairly small amount. Here in Nevada County, they charge $6 to live scan you. Save your soul. $6. They hand it to you. They do it Tuesday through Friday, I believe, till 4 o'clock in the afternoon. Truckee's a little variable. All of this stuff, always call ahead. Do not rely on even the information that's on the internet, because it is updated after changes happen. But this gives you a really good starting point. And again, I happen to be, at least as of a month ago, what's happening in Nevada County. So you have then the application is really the last 2 pages of this Attorney General handout. The last 2 pages really is only 1 page that means anything, and you fill out the top part. And you do not have to provide county or case number. You just have to provide your identifying information and swear to God that you're actually the person that's requesting this, and then provide an address where they can mail it to you. They promise to get it to you within 2 months. Again, my experience, the 5 times now that I've done this, is that you get it within about 3 weeks. So it's not the end of the world. It used to be a black hole. I mean, literally, I never heard back from those people every time I ever made a request. So it was very frustrating, but this is a good thing now. They charge $25, $35. Anyway, they charge the biggest. Okay, they charge the biggest chunk for their time and trouble. But again, they handle phone calls, and they don't yell at you. You got to do the voicemail thing, but it's pretty. But they return calls. I have also, if you were to look at let's look first at the one that says forms on it. There's a website that some of you might be familiar with. It's the California Courts website, and it's at www.courtinfo. And they have pretty near every form that's used statewide available for either downloading, or you can fill it in right on the screen of your computer and print it out already filled in. Again, cutting off my nose to spite my face, lawyers charge a lot of money for filling out these forms. And so if you can do it yourself, I highly recommend that you give it a try before you take the extra time and trouble to get a lawyer to help you out. What I've done here is just include in the second and third page the list of criminal forms, and on page where it says 2 of 3 at the top, about 3/4 of the way down the page, there's a form called a CR 180. And then I've included a copy of that particular form that's filled in. I've done it for 2 different cases. The first form in this packet, if you look up where it says case number, this is for a misdemeanor case. And the only difference is that in number 2 it asks you if your offense was a misdemeanor or a felony, and I guess that's a difference. But really, if 17B doesn't really come into play here if you have a misdemeanor conviction. It does come into play if you have a felony conviction. There's no reason, in my view, for not checking that box. If you're unsure, you can look up, and again, I've included a lot of the statutes that generally explain which crimes are wobblers. What I have not done is to provide a listing, and I know the Public Law Center has access to that in their library. There's actual lists of crimes. If you've been convicted of this crime, it is or is not a wobbler. This one is a misdemeanor. This one is a felony. And they've got charts and all that kind of stuff, and you can go look it up, and these guys will help you. In general, what you look for, if you look at your particular conviction and you look that up, the rule of thumb is if it says that it's punishable by a term in state prison or incarceration in the county jail, then it's a wobbler. If it says, low term, middle term, and high term in prison, then it's only a straight felony and it can't be 17B'd. And if it says a misdemeanor, it says 90 days maximum or 6 months maximum, then obviously it's just a misdemeanor. The second form in that packet is for a felony. We'll come back to this in just a sec. But, assuming that it is a 17B offense, the statewide form encourages us to ask the court to reduce it to a misdemeanor as part of the process. Procedurally, the court has to consider the 17B motion first if you bring it before it expunges or grants or 1203.4, because once it's granted, it's dismissed. Pretty esoteric. If you have questions, I'll answer those questions. The last forms packet is really the one that concerns most of us here. It's a Nevada County forms packet. These forms are in a state of flux, let's say. They're being updated at this time. And so what I've done is I've actually taken the liberty to change around a couple of the forms. So these forms may or may not be exactly what you submit. The first one, if you look up in the part below Superior Court of California, County of Nevada, it indicates that this is for a misdemeanor. The court here prefers that you use one of these two first forms if your conviction was a misdemeanor. They charge currently a $60 fee. The court, is it 65? 60? 60-ish? 60-ish. Yeah, $60 fee. The court clerks handle it for you. There is no court date. The judge will look at your petition back in chambers and will make a decision, almost always granting it if they can. Again, that's their general policy. It's not a rule. But they like doing that. If you've been crime-free, that's a good thing for a judge, And so they enjoy doing that, in my experience, and they'll do that usually within, again, a month and a half or 2 months. You'll get back, they'll take your address, and they'll actually mail you copies. If you need certified copies for any reason, my experience is these clerks do not automatically send you a certified copy. And so request that, and there may be an additional fee of $1.50 or $3 for each certified copy. So those first two forms are for misdemeanors, and I've labeled them as such. They do not anticipate that you're requesting a 17B. So the one thing I would say is do not use these forms in Nevada County if you have a felony wobbler. The next form is called a notice of motion and motion to declare an offense to be a misdemeanor. This would be in a situation where you have a felony conviction that you've decided is a wobbler. And so this form can be provided or obtained. All these forms can be obtained from the Public Law Center here in the law library in the courthouse. Truckee, you'll have to call the clerks up there. Maybe the Public Law Center here can help arrange to get you that material. To my knowledge, they don't have their own forms as of today yet. And so, I would call the clerks and ask them if they have their own practice or procedure, just like you should in any other county in California. Many counties have their own local forms that they use for this stuff, and this is ours. So we have a notice of motion to declare the offense to be a misdemeanor, And there's some fill in the blanks. The clerks will tell you when and where the hearing will be set, so you don't fill that in. The memorandum of points and authorities, which is the next page, goes along with that motion. It does specify a blank, assuming that you've been convicted of a penal code violation. If you've been convicted of a drug crime, it'll be called a health and safety code violation, so you'll have to modify the form for that. There are the vehicle code has some felonies in it. Fish and Game actually has some felonies. Business and Professions Code has some felonies. And some other codes have felonies. So you'd have to modify this form. They would just allow you to cross it out and print clearly what code you were convicted of and then put the section number in the blank. The rest is I've modified a little bit so that you do not have to put very much information in. The declaration, which is the next page down, has similar to the DOJ form, a lot of blanks on it. And you do need to find out from the clerks here at the courthouse. And again, my experience is they're very eager to do this for you. They like doing this kind of stuff to help you out. They can look you up in their computer or give you access to their computer themselves so that you can look it up. And you need to know the date of your conviction, if you were admitted to probation, and the date probation terminated. Now that generally the clerk will have to give you, that last date. And then I've included, or the form actually allows you to put any other reason the court should grant the motion. Again, technically the judge doesn't have to do this, so therefore anything you can do supply to provide more information that makes it more likely the judge will grant it would be great. And then you also submit an order, which the Law Center can help you with. And then what I did was to add a form that I was not provided, and it's based on one of their forms, and that's for a felony motion to dismiss pursuant to PC 1203.4. Now, you would not be asking in general for a felony to be reduced to a misdemeanor if you weren't granted probation, because you can't. So this assumes that you were put on probation. Your probation officer here in Nevada County can help you do this motion. They have their own policies. Again, the law says the instant you're off probation, you can ask for this relief. The probation department here, in my experience, tries to add rules, policies, procedures to make it more of a delay. The judges do not take a position on that. The judges are judges. The judges will hear these motions and they will grant them or deny them based on whether you're bringing it right at the end of probation or a year later. And so I encourage people to ask early and ask often. So even if you've been told no, you can come back and then use that, briefly state additional facts. So that's pretty much an overview. The Law Library has the NOLO Press book, How to Clear Your Record. NOLO Press is a great thing that I hope many of you are familiar with. They have a lot of how-to self-help law books. They're great. They started the whole thing rolling for the whole country, so they've been ripped off all across this country. And then also the Public Law Center also has a publication that's put out by the Los Angeles Neighborhood Coalition Legal Services, the LA County Neighborhood Legal Services. This is also good to look at if you really want to try to fill out your forms, but you're intimidated by the process, because this takes you step by step by step and explains each and every blank. But they're only for Los Angeles County forms. So they would educate you, help you get over your intimidation, but they wouldn't actually help you for Nevada County. Anyway, that's the publication they can show you there too. Okay, that's a nutshell. Questions, comments?
When I called I got a probation early.
Uh-huh.
Seems like everything will be
Yeah. Okay, so let's talk for a second. This lady's experience is very common. Again, as I indicated, our probation department has a policy. That policy is different than the requirements in the law. So what do? Well, you don't want to tick off your now former probation officer unless it really doesn't matter. Well, in this case, luckily, again, it really doesn't matter. The court maintains its independence from the probation department. You're allowed to file these motions in the court not because the probation officer says it's okay, but because the law allows you to. And so you do not have to follow the advice or direction of your probation officer or former probation officer in making the decision yourself whether to file this or not. My experience is that there have been often other hurdles such as you report. One thing that the probation department has started doing is there's a fee that's authorized in the statute based on the actual cost of doing these motions, and that's a maximum of $120. They've now started charging uniformly $120, and they ask the court, as a matter of their policy, not to grant the motion or to verbally grant it but not issue the paperwork until that $120 is paid. Now, my view as an attorney is, my legal advice would be that's an illegal request, because the law that you'll read, I mean, anybody can read this stuff, the law says it's regardless of a person's ability to pay, so that the court really ought to be inquiring how much, if any, of that $120 fee should be levied. The fact of the matter, you can pay it over a period of time, and they'll take your promise. A lot of times, they'll often undercut the, so to speak, the cost or adjust it so that you can still get the relief you need. You know, if you need the relief to apply for a teacher today for a job tomorrow, they're going to be much more likely to try to accommodate you. Okay. Oh, did you have a follow-up or anything? Well,
Now you're telling me
right.
that I really don't necessarily have to pay the $120.
Well,
I can ask for it to be reduced.
yeah, and your experience really bears that out. There was no provision for them to take your money. The reason is because it hadn't been ordered, and they're not allowed to just take people's money, see? So they're caught in their own problems. Yeah. The collections, revenue and collections department often collects that money for them, but again, there's no court order to collect anything, so those ladies won't take your money either. They'll tell you to wait, go to court, have the motion granted, then pay whatever fee the judge tells you to pay. My experience is the judge often doesn't tell a person to pay a fee. Okay, so the clerk, right, is writing down the order in this courtroom or upstairs. They're typing in the minutes, and there is no order to pay any fee. Okay, so what I can tell you is the law authorizes a maximum of $120 based on actual cost. What I can tell you is our probation's policy is to make people wait a year after they're off probation. That's very common for the last 120 years, 25 years. And make you pay whatever the most is they can make you pay. Okay? Because all they got to do is type out a rap sheet and send it off to the court, see? So, but I mean, they want their money. And so that's what they do. Now, you go to court, because in upstairs court, here in this county, you generally do have to appear, or your lawyer would appear if you had one. And you do or don't raise the issue. The judge does or doesn't raise the issue on his or her own volition, right? If the issue is raised, speak your truth clearly and quietly, and explain the situation to the judge. Yeah, you mean me as a lawyer? Yeah, sure. Any lawyer can. You know, most lawyers either do or don't do criminal law, but any lawyer that does criminal law can help you out doing that, and I do. And Joan wants to tell you that.
No, I have a question. Are all felonies, this comes up as confusion of the words, that comes up a lot. I have to wait a year? I thought I could do it right after I got off probation.
Well, that's the information everybody's getting today, is that they can do it right after they're off probation. However, I'm also trying to make it clear that our probation department has its own policies and its own traditions, and those are not requirements under the law. And so whether an individual chooses to follow the policies and traditions of their former probation officer is a decision each individual would make. My recommendation is file the motion. We'll see. Oh, okay, thank you very much, sir, ma'am. I'll thank you for your 1-year waiting period. We'll see. So? Well, the law requires, and these forms reflect, that the court clerk does that. They have a notice, they have a standard form that they use that's issued by the Department of Justice to update their criminal files. Well, in every other county except ours, I don't know. And in ours, that would be the individual court clerk fills out the form. And to the best of my knowledge, there's been no supervisor that's ever reviewed that. And so, in other words, the practice here for the judge to say it out loud, the court reporter to type it into her machine, okay, the court clerk to type it into the computer for the court's records, and then that person goes back in their office, pulls out, again, a thing that looks like a fingerprint card, but has different boxes on it, and sends that in with the action. However, what I started off saying years ago now is that each law enforcement agency maintains its own records, and their records may or may not show any court action whatsoever. So, again, what I want everybody to understand is sealing a record is really not, that you're not sealing anything. Let me answer the question. Because I did not provide copies of the forms, you can go back to that Attorney General website, and there's in the law, it's probably around 853 or thereabouts, that same part of the penal code provides the procedure. The Attorney General provides a form for modifying or challenging any information that they maintain. They then have a staff that go back and double check the accuracy, and they will call you. Let me finish, please. The FBI then will automatically pick up the modification. However, the FBI also has those forms, so you can write back to Quantico and you can get those forms. And again, they're pretty eager to please on that kind of stuff because they don't want to maintain inaccurate information, in my experience. So that's something to pursue, but it's not the court that you start with. It would be the person that maintains that record, which is the Department of Justice in Sacramento, the FBI in Quantico. Okay. Well, I actually promised this lady. Yeah, that's the provision that's in that 851. If you go to my handout on page, I guess I dropped the page numbering, but if you look, it'll say 2A at the top of the back of page 2. It says 2A, adult arrest, no case filed in court. Little esoteric, there's no forms, and so unless the, sorry? Yeah, so I would check with the Public Law Center, and I'd be willing to help them come up with a form if they don't have one. Yes, you've been patient. Okay, let me, I don't mean to interrupt you, but there's some, okay. The short answer is you do the same thing Ms. Bessonette does, okay? You have to get a copy of the form from the Attorney General website for challenging or modifying your information. Same thing with the FBI. We do not directly control what information is part of that record. On the other hand, there's privacy laws which try to prevent people from relying on that part of the record, okay? What I started off by doing at the beginning was kind of touching on the same thing that you brought up, which is this isn't really accurate information except for the fact that on this date, this case number, and what happened, you know? And so they can, mostly they don't, and that's a good thing, but they can, like in cases like yours. The California mental health court system is a great system. It's in its infancy. And so they're still working out what do we do with these records and how much verbiage, in other words, how many words do we keep describing the situation. If you did a bank robbery and a car theft, which was my example at the beginning, all it would have was a number. I mean, there's so many car thefts and robberies. But because you're part of the select few, they have more words for you. And I don't know what they're going to do with that stuff. But that is a problem. Also, let me just touch really quickly on drug. Let me just say drug court is also similar. We have a fairly new thing in California called Prop 36 Drug Court. And that has an automatic provision for sealing a record. That is sealing. So for 3 years they maintain it, but nobody can access it. Then it's destroyed at the end of that period of time, just literally like it never happened. This, let me just take a minute. There are certain kinds of crimes like sex offenses for which you have to register as a sex offender and you're on the little CD and stuff. There are certain kinds of crimes that the things we've been talking about this afternoon just simply do not apply to. Because of what they deal with, they're more serious or more private kinds of things. Again, if you either have questions, I would encourage you to talk to the Public Law Center. I'm happy for anybody that is here or watches the DVD. I'm happy to talk to you free, just consult with you about that situation, just so that we can do it kind of in private. Right. Well, let me go back and answer. The first question is, you can presume that there's no record, but there are things called field identification cards, which you absolutely have no control over or access to, that are kind of private public records, and the law enforcement agency maintains those. The second question is, there's another penal code section for drunk in public. Once a guy sobers up, the jail can kick you out without referring it to the prosecutor. That hasn't been used now for quite a while, so this is a good thing. Your friends all got arrested a long time ago, because what happens? Law officer discretion, okay, which is also the answer to your third question. But for your second question, the law enforcement officer can use his or her own judgment to say, let this person just sober up and let him go home. The jail charges the city law enforcement, and again, it varies by county to county. They charge a booking fee to Grass Valley Police Department, Nevada City Police, and I believe they still charge it to the CHP. They may not, but I do know they still charge it to the two city agencies, and Truckee also, which means that it costs money for a cop to take you to jail. It's actual money out of the police budget. Therefore, what they do is they do not 859B people, which is that number, anymore as a matter of policy, because when you go to court, the DA may dismiss your case, but they'll try to get you to agree to pay the booking fee. Okay? Any conviction automatically includes an order to repay the $98 booking fee. So in this county, again, that's an economic decision. It's pretty uniform throughout California now. 859B is almost a thing of the past because it actually costs money for a policeman to arrest a guy. The third question is really tough. Yes, you can go back under 851. Records generally would not be maintained in the form that you're thinking of still exist. And so the DA in this county would tend to, again, their practice would be they'd tend to resist, passive resistive kind of stuff. But you can. That's the way I was going to end this, is by saying you and I might agree that a judge should do it under those circumstances or must do it. But the truth is the judge gets to decide what he or she wants to do. Okay.
How far back can you go on DOJ mistakes or
ever?
Forever?
Yeah, if it's on your wrap, then they maintain it as a present record, and they'll change it for you. But that's only your wrap, right? That's only your automated, computerized rap sheet. That does not affect the court, any court records or law enforcement records over here. That's two separate databases. Okay. Yep. The Department of Justice, I'm sorry, the Attorney General and the Department of Justice and Bureau of Criminal Identification, yeah, it's all that, okay, it's all those guys. Only two, Chris. One is the feds, one is the state. Okay? So the FBI does all the feds for all the states. Your state does your state. For what? Yeah. Nevada uses different numbering system than California for their crimes, so that California lumps everything into one number called car taking. Nevada has, and I don't know the number, but it would be 303.012, 303.116, and they keep going forever. And so they often get confused. The FBI record is the one that Nevada is accessing there. Again, if you're in one of the tri-county areas, then like us, then they can directly access Nevada state databases and vice versa. So that, again, yeah. Yeah, good. Yeah, you've brought up a good question that I'm sort of embarrassed that I missed, although you'd think with this much time talking about this I would have covered it all. The DMV actually does maintain a separate printout or separate rap sheet, and DOJ couldn't care less about most of that stuff. They do care about car takings, they do care about DUIs, and they do care about criminal vehicle code violations involving using cars to commit crimes. Very, very small number of cases, okay? Even if you got arrested while in a car. I mean, that doesn't count. Using a car to transport a minor across state lines, that kind of thing. Otherwise, DOJ couldn't care less, FBI couldn't care less. So DMV does maintain a separate system. Again, for those of you who have requests or considerations for modifying your criminal records, DMV, it's the same thing. You can apply at our local DMV office, get a DMV printout. They'll actually print it out for you right then and there. My recollection is they charge about $15 though, so it's fairly expensive. They have 4 different levels of printouts, and they'll only give you access to 3 without going through some other hoops. But in general, that gives you all the information you need to know. And then they also maintain their own records for changing information. You ought to be on the DOJ printout and not just the DMV printout, but it doesn't matter because you need to do both. You need to check with both. Questions? Comments? Right. Well, it's not hopeless. If you can remember where you were when you got arrested, and that's good. Okay, good for you. Okay. And but in general, for everybody else in the room, if you don't know some of this information, if you know what county you were in when this all happened 100 years ago, then what you can do is to call the local county clerks, and they'll often look it up for you right then and there. Or they even nowadays have a lot of counties have databases online that you can just look yourself up in. That gives you the case number. And then from that, you can either buy a copy of the report and the court record and then file your motion, or you can just file your or call the local public law thing, for instance, in San Jose, I had some experience with. If you call those guys, they'll do it for you. So again, every county is just a little bit different. You don't even have to appear in some counties.